We wanted to put together a webinar for the family department for those parents and families who are dealing with children with special needs, because I feel like they often get overlooked and they can be some of the most complicated cases that we deal with. So I wanted to welcome you and to introduce you to the co-panelists. My co-panelist, Dr. Susan Carr-Bernstein, is a certified divorce coach. She is a certified high conflict divorce coach with a specialty in post-divorce transition and recovery. She also is a mom, a best-selling author, a leader of Best to Divorce. She's a member of the National Association of Divorce Professionals, as well as the Divorce Coalition. She has a particular affinity for families and people with children of special needs, as she has children with special needs, and she is like an unbelievable resource in terms of dealing with issues that you are facing and that, quite frankly, divorce lawyers may not always be aware of. So it is invaluable to have a resource like Dr. Susan Carr-Bernstein. And then I also have with me Elizabeth McKenna, who I've known for several years at this point. She is with Merrill Lynch. She is a Senior Vice President, Wealth Management Advisor. She is phenomenal. Her mission is to help families work through wealth and transition. She has a particular emphasis with the needs of any investor. She has a particular emphasis on families with special needs because, again, there are special, unique financial challenges, and she is a wealth of information on those issues in terms of how to handle those transitions, not just now in the divorce, but things that you are going to encounter going forward that you should be aware of. Lisa Roscos is senior counsel with me at Cohen Seglius, Powell, Greenhill and Furman, and she joined us just a little bit ago, but she is very dynamic and has an extensive background in dealing with people with domestic violence and some special needs. And I will tell you that other than myself, the other panelists are blessed and have the unique gift of the child with special needs. And so they have a lot of additional insight that maybe I do not have, other than what I have gathered, because this has been an issue that I feel often gets overlooked. So with that, let's get started and let's talk through some of these issues. So Lisa, let's talk through why does special needs divorce require a different conversation? From the attorney's perspective, what makes a divorce involving a child with special needs legally different than, say, a typical divorce?
So from the legal perspective, there's an additional level of depth to everything when you're considering a divorce with a special needs child. So when we're looking at issues with children in New Jersey, we're generally using this best interest of the child standard. But with special needs children, that standard takes on a lot more meaning than our regular divorce case. So you're not just looking at what we normally look at: stability, history of domestic violence, parental cooperation for the child. You're also looking at the child's medical needs, developmental needs, educational needs to a more extreme extent. Are there IEPs? What schools? Even things like residential custody take on a different meaning, a different depth with this. You're looking at different towns in New Jersey's. Who has better programs? Who has the better specialties for your child when you're deciding where the child is going to live? Who's going to be parent and primary residence? It's no longer just about location, transportation. It's a much more in-depth consideration than what we normally have in a divorce without a special needs child. And then, of course, there's a financial aspect, which becomes more complicated as well. And we're going to talk about that extensively. But child support, finances for the child, you have to be very careful that you're not disqualifying the child from services and financial help they can be getting. Child support can extend far beyond what we normally consider for child support. Age of 19, if they're going to college past 23, it can go indefinitely for a child with special needs if they're not able to gain independence on their own. And that's something that is unique to special needs divorce cases as well. So this requires a lot more financial planning. It requires a lot more consideration long-term to what you're dealing with, not only financially, but logistically for the welfare of the child and the best interest of the child. And there's a heightened need to work with other individuals and not just one lawyer or you and your adversary in the case.
So having someone like a Beth McKenna or a Dr. Bernstein is important in those cases. Is that what I hear you saying?
Absolutely.
And the
Absolutely.
other and the other thing, just as a follow-up, I think what I also hear you saying is that clients are going to be the ones in the best position with the assistance of their professionals to lay out for us, the lawyers, tell me what I need to know in terms of what your children need. This is sort of in the custody factors, the other factors that we have to consider. Those sound like they're going to be way more important in a case where there's a child with special needs. And the parents, the clients are going to be the ones who are going to best educate us so that we can tell why, we can explain to a court why the cookie cutter regular parenting schedule isn't going to work. Beth, so what financial planning conversations become really especially important? I mean, Lisa just talked about child support and what that is, but that seems to segue into what financial conversations do the clients need to be having with us,
Sure,
with you?
sure. Well, the key is to understand the situation with a special needs child, a child who may never become fully independent and may require the parent's help for the rest of the parent's lives. First, you understand that part of the aspect of the divorce discussion, and then how it fits into the overall picture. And this affects all aspects of the divorce, from equitable distribution of assets to child support, alimony, etc. The divorce discussion, as Lisa mentioned, is also impacted by potential state and federal benefits to the child, which really can be difficult to gauge, particularly if the child is young. What I do is I actually create two plans, one for the parents and the typical children, for example, and one for the special needs child, because that has to go throughout the child's life. So very, very important to understand the length of time that we are considering in a divorce case for a special needs child. I estimate the benefits that they may be eligible for when they're young. You can usually have some indication, although it gets easier as the child gets older. But we update as we receive more information over time. But it's truly critical to look at all aspects of the full life of the special needs child when approaching divorce.
So, Dr. Bernstein, this sounds very stressful. If I'm sitting in the audience, I'm looking at a screen with four different professionals and saying to myself, I have a special needs child I am currently managing with all of their professionals. I may have a child who is not neurodivergent, and I have to manage that separately. So now there's a divorce. What are parents emotionally facing and carrying when a divorce gets added to this dynamic?
It's a great question. And I think everyone on the screen is thinking the same thing. And certainly when people get married, they don't have a crystal ball that says they might get divorced. When they get pregnant, they don't have a crystal ball that says that their child's going to have special needs, right? And of course, there's a whole range of special needs. But we're talking about the ones who need all that additional care and potentially who will be dependent lifelong. And so trying to deal with that extra weight on their shoulders for all the extra time and explaining to people who truly don't get it, right? You mentioned how several of us here, like I have 3 children, my oldest has severe special needs. So really being able to understand the mindset yourself and communicate it to others and accept it and know that you are that advocate, right? And so normally, hopefully, a married family is working together. The couples are working together. But when they're divorcing, sometimes out of spite and not the child's best interest, one parent will just say no, right? And just out of spite. And so you're dealing with what's best for the child, the divorce, the other parent putting obstacles in the way, and it can certainly seem overwhelming. Having gone through this myself, I created a certified special needs divorce coaching curriculum. So there are special needs divorce coaches like myself that I train out there as well throughout the country who can help you. And it's not like oh my gosh, I have to pay for an attorney and a financial, specialist and a therapist and this. Just sometimes 1 or 2 sessions with a coach to help you gain clarity, figure out a plan to get unstuck, and know how to communicate with all parties involved can truly make a big difference. Because as Elizabeth mentioned, there's a lot of additional financial needs. And as Lisa mentioned, there's a lot more decision making related to the parenting time and all the shared decisions that those parents are going to have to make. So I help an individual kind of figure out a plan to get unstuck, to get through those huge obstacles that feel like they're in their way.
But it also sounds like to me from both you and Beth that having somebody like you're right, even if you're not with me every step of the way, the two of you can help me translate to a lawyer, and I use that word intentionally, translate to a lawyer what it is that we need to understand in order to be able to convey the severity about what is going on and why these things are so important. And no, we can't just gloss over it and deal with it later. What are the terminology, what are the issues that are going on that I, as a lawyer, need to understand in order to best advocate for my client and their children? So thank you. Lisa, what should we be thinking about? You talked about parenting plans a bit, and Dr. Bernstein did as well, but what should be built into a parenting plan when you have a child with special needs?
Yeah, so you're going to want to be thinking a little more long term, I think, with a child with special needs, a little more forward thinking with a parenting plan and a little more depth, like I said. Something a little more specific, a little more durable than your standard parenting time arrangement. Vague decision making language, like we sometimes use in divorce, may not be workable. You might want a little more clarity on what parent is making what decisions. For example, you might want to give a defined idea of who makes medical decisions, who makes educational decisions, or if they're being joint decisions and you're coming to a head, put in a tiebreaker so that how a tiebreaker is going to work so that these decisions are being made and being made quickly and not having to be relitigated in court. Thinking forward with these things will prevent you from having to go back and litigate issues that may need to be dealt with pretty quickly with a special needs child. And with parenting plans, you want to pay specific attention to routine and structure with children.
Why?
Special needs children thrive off of routine, and that goes across many different diagnoses in my experience. Routine and structure is incredibly important, and it applies not just to the developmental needs and the behavioral needs of the children. It also goes for things like appointments, therapies, giving medications. You don't want a child missing their weekly therapies and regressing because the parenting time schedule isn't working. You don't want confusion in medications because there's confusion in the schedule or the routine isn't working out. So that all has to be taken into consideration. I had a case some time ago, years ago now, in Union County, and it was a restraining order. There was a final restraining order between the parties. So we're talking extremely high conflict. And unfortunately, the father did not understand the child's diagnosis, did not understand the need for routine, and wanted a very loose, as needed parenting schedule. My client was terrified. The child is going to freak out. This is not going to work. This is going to be a nightmare. It's going to be bad for all of the child's routines, all of the child's behavioral progress we've made, developmental progress we've made. Father was insistent. Luckily, there was a judge who had a grandchild with a similar diagnosis and understood the issues and the problems, and basically came down with, you're going to follow this parenting plan very specifically the way it is suggested, or you're not going to have parenting time, because it is that important to follow routine and structure. So making sure you have that all built into, based on the child's specific needs, consistency in diet, sleep, medications, all of that. Because small deviations with a special needs child can have more of an effect than with a child without special needs. So it does have to get more in depth with that.
So, Susan, you've talked about we just talked about parenting plans. I want to talk about, because we didn't talk about siblings. And so you've talked to me about something called a tiered parenting plan. What is that and why is that important to actually consider? Because I will tell you, and I don't know if there are any lawyers in the audience, but that is not a phrase that I mean, I've done different plans for different kids for different reasons, but I've never talked about the specific language, a tiered parenting plan.
Well, piggybacking on what Lisa said, as far as having it very unique, not cookie cutter for each individual family is so important. And so a tiered parenting plan not only looks at the child or children, right? Sometimes there's multiple children that have special needs in one family, or, one neurodivergent sibling and one not. As far as what currently is the best, the specific details, and when to revisit that, right? Especially if there's young children. And it's not just at ages. Sometimes other parenting plans might say, oh, when they get to high school, we'll meet back with a mediator, right? So let's look at some developmental stages. Let's look at some benchmarks. Let's talk about how to communicate. I'm very big into parenting apps, not making the children the messenger, making sure information related to the schedule, decision making, reimbursement of finances are all in the parenting app. And, as everyone's been hearing here, it's overwhelming, right? It's overwhelming. So if all communication can be on one place, if the details are in agreement, the more details, the better, not just Friday to Sunday, alternating weekends. What time Friday? Who's picking up? What should the child be bringing, right? Really specific details of how ideally you're co-parenting. If it's high conflict, you might be parallel parenting in Yellow Rock, right? Just specifically talking about the child themselves in a business-like manner, which I help parents do. And if there's any third parties involved, how are we communicating with them? So a tier plan, in simple terms, is a unique detailed plan looking at the child or children, the specific family, when ages/developmental benchmarks are met, and when to be revisited, and how to communicate all of that.
So you talked about mediation, and I've increasingly have been moving my practice into ADR, what I call ADR, alternate dispute resolution mediation. I sit here and I hear everything you're saying, and I agree, obviously, given your experience with everything you're saying, but I don't find that courts have even remotely any ability to handle what you're discussing, whether it's a tiered plan or it's looking at developmental stages instead of ages, or creating a plan that allows for siblings to have a different schedule potentially than the child who's neurodivergent. And how does that get managed? And apps, I mean, I too agree that apps are phenomenal. I think they are very good. You can lay out detailed schedule, but I come back to the mediation. I say to people, everybody is convinced that you must go to court and battle it out, whatever it is, in order to reach the resolution in your case. And my experience has been, when you have cases like these, where you have to be very thoughtful and not be rushed by a court's time frame, because the court's going to put you on their time frame and you have to meet it. So in addition to everything else you are trying to manage in your lives, plus the divorce, now you have to meet a court schedule, which may not meet anybody's schedule. Mediation, even arbitration, you set all that up privately, independently, and you work at your own speed, and you can involve people in that process. I mean, you can involve people behind the scenes in a divorce process that's litigated, like a Beth McKenna or a Dr. Bernstein, but it's harder. But when you're mediating, you can bring these people in directly and have a session and say, okay, we need to address parenting. Dr. Bernstein, can you come join us for that session? Okay, we need to look at what the financials look like, long-term, short-term. Beth, can you join us, and sit with us for that session? You can be way more creative in either of those areas. And if there is an impasse that you can't reach, the uniqueness in New Jersey is you can go from mediation to arbitration with the same person. If you feel that person understands the dynamics well enough, you can, it's called a Minkowitz waiver. I don't want to overwhelm, but like, you can take that mediator and make them an arbitrator and say, listen, we agreed to 90% of the issues. We need you to call these 10%. And you don't start over. But you have the control. I mean, anyone else, between, Beth or Dr. Bernstein, any other thoughts on mediation as an alternative or arbitration as alternatives?
100% mediation is the best way to go, if you can get it done.
And I'll add to,
Yeah, I would 100% say go for that. Try your best to get it done in mediation. If you have to go to arbitration, like you said, Carolyn, on maybe one or two issues, fine. But as far as litigating, very difficult.
I'll
Dr.
add to
Bernstein?
that. Yeah, in general, when you litigate, you get what I call a skeleton agreement from the judge. Very little details, which is the exact opposite that you need. And sometimes I know in high conflict divorce, so I define high conflict, which is one of my specialties, custody battles, hidden money, domestic abuse. There's a lot of families that have a special needs child who have a parent with a mental health diagnosis or an addiction or personality disorder. So you're dealing with, a lot of you are dealing with an ex who also has some additional needs, right? So sometimes the court needs you to move it along with certain deadlines, but that doesn't mean you can't mediate, right? It's just saying, if we can't come to an agreement, we're seeing the judge in 30 days. So let's see if we can sit with a mediator, because if you get an agreement from the judge, it's a skeleton agreement. There's not details, and the chance of you going back to court post-divorce is very high. When
Yeah.
you mediate, you're in control of those decisions. And most of the time, you're much happier with the outcome, and you've saved time and money and headaches.
Yeah. Okay, Beth, now we're back to you. We've got to talk about you just sort of laid it out there a little bit at the beginning and said, well, we have lots of problems on the financial side that we're going to have to talk about. Let's talk about some of them. We have governmental benefits like SSI and Medicaid. Again, in 90% of divorces, nobody even knows what these are, nor do they talk about them. What do parents need to understand about how divorce decisions are going to impact those benefits?
Yeah, it's critical that all this is understood, and it's very complex. So one of the most important things to remember is that child support payments can count as unearned income for the child. It may affect supplemental security income or SSI. Those payments can even reduce SSI on a dollar for dollar basis. If the child becomes ineligible for SSI, they could become ineligible for Medicaid, and from there, ineligible from various state benefits for supported living. So the best idea is to have the child support for the special needs child paid directly into a special needs trust. Now, the trust that would be used for this payment has to be a first-party special needs trust. As the money in the trust, you might think, well, particularly a minor child, it's going to be paid to the custodial parent. It's actually considered the child's own money. So the first-party trust should, and it has to be irrevocable. So a first-party trust can only be used for supplemental needs. So possibly using an ABLE account might be a better choice. So they can be used for those types of payments. They are subject to Medicaid payback as a first-party special needs trust is, but the difference is that the ABLE account can be used for a much broader range of needs. The special
Okay, so
needs
pause for a
individual-
second. Pause, because now you're talking about something I've not heard of. I shan't say never, but like I could probably count on one hand. What's an ABLE account?
Well, I'm going to get into it in a little more detail
Okay.
later.
Okay.
But it's called Achieving a Better Life Experience account. They're relatively new. They were just brought about in 2014.
Okay.
And they are a great tool, but I will get into it a little bit later.
Okay. Sorry, I
they
interrupted
just-
you on the
it's-
trust.
Yeah, it's a little bit, it's definitely more flexible in terms of what the money can be used for. So I think it's a really good, a good tool for this type of thing for the child support, definitely.
Okay.
Now, I just wanted to mention, as Lisa said, another key factor to be considered is that the child support may possibly be indicated for the life of a child with special needs. It could happen, right? If a child will never be independent or able to support himself or herself, the courts might choose to mandate lifetime support from the non-custodial parent. And I'll just use as an example a case I was involved with. The non-custodial parent was demanding alimony. So the attorney for the custodial parent said, well, yes, you technically probably are entitled to some alimony, but guess what? You're going to be paying a whole big chunk of that back, if not practically all of it, in child support, maybe for the rest of your life. So needless to say, that actually was resolved in mediation with no alimony, no child support, and a simple division of assets. So things like this are very important. As I said, mediation is key to being able to sort these things out, you know, when everybody is hopefully working for the benefit of the children.
Okay, so Lisa, let's talk about that, because now you're the divorce lawyer, and you are faced with a case with a child who's neurodivergent. When do you begin talking about child support and special needs and even emancipation, which is when the child will, according to the law, no longer need support, which is highly unlikely in these cases. So or there may be less support needed later on, but termination of all support is highly unlikely. So, when do you start having these conversations?
As soon as possible, as early as possible, ideally at the very start of the divorce process. These are not add-on or last step decisions. A special needs trust, these considerations really inform how the entire settlement is structured, how the entire financial planning for the divorce should go. They should not be considerations later on. So this is something you're going to want to be talking with your clients about right when they're through the door. It can shape for the reasons that Beth discussed. You don't want to accidentally end up doing something in a divorce that later disqualifies your client's children or child from having SSI or Medicaid or benefits that they may need because you weren't thinking about this in your client's divorce. Sometimes these are young children. They're not at this stage yet. You're not thinking about this stuff yet at the time of the divorce, but as the attorney, it's your responsibility to be thinking about this from the beginning. So these considerations shape equitable distribution. They shape how child support, alimony are going to be structured. And doing it now, doing it as soon as you're starting the divorce process with your client is going to avoid having to fix costly mistakes later on for your client. And that could potentially harm the child and their financial interest in the future. So you're not going to have to try to, and there's some case law on this too, backtracking and unwinding things because you weren't considering a special needs trust or where support was going to go and how it was going to affect the child at the time of divorce. So again, this allows for coordination with estate planning at the time of divorce. This divorce with a special needs child, like we've emphasized, should not be happening in a vacuum. Mediation, during the divorce process is something you should be talking with your client with out of the gate too, to work on all of these concepts and get everybody on the same page with how this should work.
And Lisa,
so
you just said
yep.
something important, because we don't have someone here to talk about that per se, not that we all don't know them, but you're going to need someone who does trust and estates work, right? You're going to need someone who's going to craft the special needs trust. And that's not going to be, hey, I need a special needs trust. Here you go. That's going to involve conversations. And you also said estate planning. I mean, parties may wish to, and I had a case like this. I had parties whose son was not independent. He was 28. He had impulse control issues. He would run outside naked. He would be very loud outside. So they had to make plans to sell their marital property that they had acquired that was sort of set up to accommodate the fact that it wouldn't disturb neighbors and they could work through the issues and locate something that would work longer term. And they were going to, so they bought a farm property, not huge, but like 10-acre property that had a second house. so that the other parent could be there. And these were people in their 60s or 70s, and they had to work with their estate planners as to how to fund all of this without running afoul of disqualifying this child from his benefits. I mean, it was complicated, and we were very thoughtful and paused when we needed to say, okay, trust and estates need some time to chat. We're pausing the discussions in the divorce. When they've figured this thing out, then we will come back and have a conversation, because that was going to shape how monies got paid. So we don't have someone here who does that work. We all know people who do that work, but that's just another person. But again, they come in and they go out in the way that I just said. We didn't have 6 lawyers sitting in a room. The 2 divorce lawyers said, up, pause. And we were mediating. We were like, okay, pause on this. Go have a conversation, come back, go find the property. They had to plan out selling the property and locate the other property. That took them 6 months. So, that in a litigated case would never have, you could never have had that. So, and then the other question, and I think this is probably a simple answer that probably everybody in this webinar could say, is how do the lawyers prevent future litigation on post-divorce problems?
I mean, and that goes to the planning ahead, to addressing these issues now and not waiting for things to happen in the future. So eliminating any ambiguities in a well-crafted, well-thought-out, specialized plan, planning for change, with your child. So you don't necessarily know what the special needs child's needs are going to be as they grow older, especially if you're dealing with a younger child at the time of divorce. So you plan for that change and how change should happen and how we modify things, and you build that in. You build the structure into the plan so that there is no ambiguity on how things should work and be decided. So having this all worked out in the beginning is how we avoid expensive, frustrating litigation in the future, anticipating what high friction issues would be and addressing them up front, anticipating these potential future financial issues, addressing them up front. Has giving clear paths to resolution in the future. And for us as attorneys, recognizing that, yes, we're lawyers and we know a lot, but we don't know everything, and we do need outside sources is important too.
Yep. So Beth, you started to talk about this before, and then I jumped ahead, but talk to us about things like ABLE accounts, and the child's money, and things like excess from SSD or a job. I mean, many of these children will hold a job. How is all of and again, when you have a 3 or a 4-year-old in a divorce case, we're not thinking about child working at 24, 25 and how that's going to impact. So talk to us about all of that.
Very complex, very difficult, but I'll go through the tools
Okay.
that can be used for all of this in greater detail. So the first one I've already mentioned, of course, is the first party special needs trust. That's also referred to as a self-settled trust. It's a trust that's used when the money involved is the special needs individual's own money. And the special needs individual is technically both the grantor and the beneficiary. Typically used in accident settlements, or when a mistake is made, such as an inheritance from a family member who didn't know that the special needs child can't own money in their own name. So in order for assets of this type of trust to not count for Medicaid or SSI purposes, federal law requires that the beneficiary must be under the age of 65 when the trust is created and funded. The trust must be irrevocable and provide that Medicaid will be reimbursed upon the beneficiary's death or upon termination of the trust, whichever occurs first. And the trust must be administered for the sole benefit of the beneficiary. In general, a first-party special needs trust receives greater scrutiny from the courts, as the courts are usually involved from the start. So it's likely beneficial to have a professional trustee handle a first-party special needs trust, and that is certainly my recommendation. A third-party special needs trust, on the other hand, is generally the parents or other family members' money that they have gifted to the special needs individual. As such, Medicaid payback is not mandated. However, a third-party special needs trust must also be used for supplemental needs only, just like a first-party trust, to enhance the life of the special needs individual and not to pay for basic needs as other trusts would do. So some examples of supplemental needs could include vacations, a gym or club membership, dance lessons, etc. Things that'll be fun rather than, just support payments, because that is covered by those benefits that we're trying to protect. Okay, so because Medicaid payback is not a factor unless mistakes are made with distributions, which is another issue, remainder beneficiaries, such as the parents of their children, can also receive benefits from the trust. Now, that's typically after the passing of the special needs individual, but it can be structured to include other beneficiaries during the life of the special needs individual. So trustees can be parents or other family members, or a professional trustee can be considered. So, but there's a third type of trust that not everybody knows about. So these trusts are pooled trusts, and they are managed by nonprofit organizations. In New Jersey, Plan NJ runs a pooled trust for special needs individuals, and where they combine the resources of many beneficiaries for the purposes of administrative cost effectiveness, investment optimization. So individuals have their own sub-accounts, and they receive a proportionate share of the entire fund's earnings. A pooled trust can be either first party or third party. In a first party trust, any money left in the sub-account after a special needs individual passes away can be retained by the nonprofit that is managing the trust. If the nonprofit chooses not to do so, then Medicaid payback would apply. Pooled trust will generally accept any kind of money, and this is good because a lot of times if you want a professional trustee, such as an attorney, for example, they're looking at, in excess of $500,000 to make it worth their time. The pooled trust will generally accept any amount of money, so it makes it easier to receive a professional trustee at a reasonable cost. Okay, finally, ABLE accounts. So as we got into a little bit before, ABLE accounts were created by the Achieving a Better Life Experience Act in 2014. So the goal was to create another vehicle for protecting the benefits of special needs individuals that would be more flexible in terms of use and ease of setup relative to trusts. And they are very easy to set up. Now, I think it's about 20 or 30 states that now have direct ABLE accounts that you can set up online. It's easy. I did it for my son, New Jersey ABLE. Easy. So you put the money in the account. I actually tend to view them as 529s for special needs individuals, and they work basically the same way. You put the money in the account after taxes, and the gains are tax-free if used appropriately, just like a 529. The annual contribution limit for an ABLE account is $20,000 in 2026. Now, unlike a 529, where you can have various people placing the max amount in, it's actually $20,000 is a limit for an ABLE account. The special needs individual's disability or blindness must have occurred before age 46. And that's actually new as of this year. It used to be 26, and it was raised to 46 this year, which is really a good thing, particularly for special needs individuals who have mental health issues that may not present themselves until later in their lives. So that's just one example, but that's a very good thing for people who have that situation. ABLE accounts are disregarded for most benefits. They're disregarded up to $100,000 for SSI. And Medicaid, though, is not impacted over the 100,000 mark, which is a good thing. So, and this is, you mentioned special needs people who work, right? So there is another, there was basically a modification called the Able to Work situation, where a person who is working can put up to about $15,000. That was as of 2025. I think it's a little bit higher in 2026, or their entire earnings for a year into their ABLE account. So the main difference with ABLEs is they're not restricted to supplemental needs, which is great. So they can fund a whole range of needs for a special needs individual. They can even have a debit card on the account if they're able to handle that. So it's an excellent tool, as far as I'm considered, that can be used in conjunction with a trust, since there's a limit on the amount of money that can be put into one. So you probably still, or you may still need a supplemental or a special needs trust. But I think an ABLE account is a tremendous tool. And I find that not many people really know about them because they're relatively new. So, that's a thing that I try to get out to, potential clients, anybody who's going to come to our events, to let them know that ABLE accounts are out there and definitely, in my opinion, should be used. Now, regarding long-term care planning, the idea is to replace the irreplaceable parent, because we are truly irreplaceable. So we can only do the best we can do, right? With funds to create a happy and healthy life for the special needs individual without disqualifying them for the state and federal benefits to which they're entitled. So the planning for long-term care starts when your child's young, by doing your best to preserve any benefits they may be eligible for, while providing a legacy to enhance their quality of life when you're no longer there to provide for them.
Okay, thank you. Okay, Dr. Bernstein, let's get into some touchy-feely. How do we manage the conflict here? How do we prevent some post-divorce problems? We got very serious financial advice now. Now we need some emotional support. How do we do this?
Good question. And it really is the team approach. So someone will contact me and say, I'm just so overwhelmed. I have this amazing financial specialist, Elizabeth, and this amazing attorney, Lisa, and this amazing attorney, mediator, Carolyn. What do I do? Right. So just helping them gain clarity, helping them gain what I call radical acceptance, which is really the reality, right? What would happen if you went to court? What does the law say? What are the right questions to ask your legal and financial team? And then knowing what the reality is in your unique situation, which path do you want to take, right? So many times people can't even figure out if there's one path, let alone, okay, there's a couple different options, what obstacles are in the way. And going back to the contract, right? When it's overwhelming for them, a divorce agreement really is a marital settlement agreement. It's a contract. It's a legal contract. So talking about, can they add some if this, then that, right? So if someone has a young child, currently we're seeing this, if they are emancipated and of emancipation age, but still dependent, then this kicks in, right? So having a lot of if this, then that. So, hey, page 7, paragraph 3 says, if they don't graduate high school or if they're not going to be able to work, here's what happens. Here's who splits the cost of applying for guardianship, or here's who will help them down the road financially or physically. Here's what we agree related to a group home or a special needs school or vocational. So a lot of if then this. And then I also think it's very important, even if the family is amicable during this stage, you never know what future partners whisper in someone's ear, what people hear that's false or not true. So having a lot of deadlines and then a wonderful default section. Whenever someone comes to me post-divorce, and about a third of my clients are post-divorce, I said, well, what does your default section say? And shockingly, some divorce agreements don't even have it. They don't have what happens if someone doesn't follow through what they're supposed to, what the consequences are, what deadlines we're supposed to be. So really saying, here's your agreement, but let's think about the future, put in some if-thens, put in some deadlines, and put in what happens if they stop paying? What will happen then? And help them sleep better at night, knowing that they have the right legal and financial team, and they've put in the right things in their agreement to get them through any potential obstacles in the way.
And how do you help? But what tools do you help? What tools help parents focus on the child's needs other than the marital conflict? It sort of ties into, how do you get them to communicate better for the benefit of this child that they brought into this world?
Absolutely. And remember, sometimes it's subjective because one parent thinks that what they want is the best and the other parent thinks what they want is the best, right? So really, really also sometimes bringing in the non-divorce experts such as the pediatrician, the therapist, the child therapist, right? And at the IP meeting, what does their IP say? What does the child say if they are verbal, right? What do they show if they're not verbal? What preferences do they show? So really helping them take a step back, because so many times people think that they want what's best, but are you doing this just in spite? Is it best now and also best later? Is it best just for that child or the whole family, right? And so things get stuck, just like people get stuck on, we have to keep the same home. We have to keep the home. Who cares if we can't afford the home? Who cares if there's no emergency fund for the home, right? And so helping them be realistic, right? Asking the right questions, but also helping for self-care, right? It's that airplane method where you hear anytime you fly, if there's an emergency, put the mask on yourself before you help others. What are they doing for self-care? What can they look forward to? How can they not let this consume them? If their life is a pizza pie, their ex is going to be only one slice. There's going to be tons of fireballs being thrown at them, smoke and mirror show, lots of, how can they not let it consume them? How can they live their best life, yet being the advocate? And also, how can they define who they are, right? Not just a mom, right? Like I am, of course, a mom, but I'm also have some other things as well, right? I have my career, I have my hobbies, I have my extended family, and my alone time. So helping them, what I say is time hop, right? Where do you see yourself in 3 to 5 years? And how are we going to get there? And when you look back, are you going to say, I'm proud of myself, I handled it in a classy way, and I'm glad I thought through instead of allowed my ex to trigger me or the system to trigger me?
It's very good. So you talked about the fact that oftentimes you see in agreements that your clients, you have a third of clients that come to you post-divorce, and oftentimes there's no default. I mean, what about a default that says, listen, if this, then that, but now we have a gap for some reason because we just didn't anticipate it, or somebody didn't do something they were supposed to do. What about putting in very detailed language about mediation and structuring how that mediation is going to occur? What professionals must be involved and contacted in the event that there is an issue? If there's a financial issue, the parties are required to contact Ms. McKenna and or any other financial planner if Ms. McKenna is not available within 10 days and receive her opinion. The parties will then contact a mediator within 10 days. I mean, we often say in our agreements, particularly in my office, if the parties can't reach an agreement, it's mediation or arbitration. It depends on whatever the issue is. And there's a whole host of reasons that is not the subject of this webinar as to why we do that. But in the case like this, put in something very structured, because otherwise he's in default or she's in default. You have to go to court. I don't know how long that will take. And there's no deadline. So now you've put families who everybody here has said structure is important and thrown them into limbo. Thoughts about that as your resolution? I mean, even if it's an arbitration process that just says decision will be done in 45 days, you can do that.
Absolutely. Absolutely. And it goes back to why mediation's so important, why that third party tiebreaker is so important, why knowing that you can't know everything, but we're trying to capture this without spending, tons of money and tons of weeks and months waiting for a judge to hear it. So I absolutely agree.
Well, it's sort of like my phrase that I say to people every once in a while: if you fail to plan, then you plan to fail.
Yeah.
And you just cannot do that in these cases. So I want to talk a little bit about why is it important? I think we've talked about it a little bit throughout, but I want everyone to take a moment and from their different perspectives, why is it important to have a professional or multi-professional team? Again, not all at once. I'm not saying we all need to be in the room at once like this, but having a multi-professional team in cases where you have a neurodivergent child or children, so important. Lisa, I mean, why is it so important for a divorce attorney not to work in a silo and to have other professionals involved?
Right. I mean, as we've been saying, these issues, especially with a special needs divorce, they don't neatly stay within the boundaries of family law. You know, as divorce attorneys, we call in experts for lots of other reasons. We bring in forensics accountants, and we do business evaluations and we deal with, you know, high value assets and everything. Why wouldn't we bring in additional people to help with a special needs case with a special needs child? They're a different type of expert. So we do it with other things when it deals with finances and other areas of divorce. Why wouldn't we do it for a special needs child and with a family dealing with a special needs child? And I think that's something that maybe divorce attorneys kind of overlook. So we recognize we're not experts in those cases. We should recognize we are not able to you know, necessarily have all of the expertise on the specialists in trust and estates, or even with some of the schooling, which we didn't get as in depth in as the finances, but IEPs, dealing with the school systems in getting your kid the right therapies, programs, what they are entitled to through public education and school systems can be a nightmare, and that needs to be addressed as well. And what parent is dealing with and how, and we're not specialists on those things. So we do it in every other divorce case for different issues. We should be doing it in special needs divorce cases as well.
So Beth, how does this having a multi-professional team, how does this collaboration help clients prevent costly mistakes?
Well, yeah, as I've been, we've been chatting about, there's so many mistakes that can be made in special needs planning. And unlike a typical divorce, now, I always advocate and it sounds like you definitely do that because you're all wonderful, to have financial planners in the mix because, we can do projections and, can be very, very helpful. But unlike with a special needs case, you can kind of, if you have to, you can go back and make changes, not easily, but it's certainly possible. With some situations with special needs, it can be devastating potentially. And, benefits lost, millions and millions of dollars worth over the lifetime of a child lost. We have to be cognizant of that and, bringing all aspects of that into play and bringing all professionals, I think, into play is a great idea. So that you're making sure that you're hitting all the bases on these particular situations that are so critical. Like top among them, that the child must never have more than $2,000 in their own name, ever.
Yeah.
So
which seems really hard to plan for. I mean, birthday money could be $2,000 in a heartbeat.
That's why
So,
everybody has to know.
yeah,
And that has to be a part probably of an agreement that both sides are informing their respective families that they have to be aware of this. And if they're going to either leave a legacy or a very significant gift, could be, okay, I gave the other kids X amount for college.
right.
And I'm just going to do it for you too, or for this one too.
Right.
No, start an ABLE account, So I think that probably has to be part of any agreement, is that that's all going to be covered. So yeah, I think creating a team is, I think, critical for these types of cases.
So, Susan, listen, I will tell you, I mean, as the divorce lawyer, everyone always says to me, divorce coach, is that like a life coach? What do I need a divorce coach for? What do these people do? But, from your perspective, having done this and having developed curriculum even to deal with this, how does having the emotional and practical, like sounding board support that oftentimes these families, unless they're part of a larger group of other, they don't have it. They're sort of siloed. Like, how is having the emotional and practical support change their experience in the divorce process?
in so many ways. Just to name a couple, one, having a lifeline, right? My clients can text me 24/7. They don't wake me when I'm asleep because I turn off my phone, but they know they have that lifeline, right? Number two, knowing they're not alone, right? Like I created www.divorcewithspecialneedschildren.com. We do a free annual summit. We do free monthly support groups. So just knowing you're not alone, because when you have a special needs child and you have a divorce, you're walking around thinking, I don't have any friends or family members or coworkers who get it, right? But there are people out there who get it. And there are resources like these amazing professionals right here today that you see. So being a connector, one thing I do as a certified divorce coach is connect people with the right resources. And that's why this is so important. That's why I'm glad we're talking. I'm glad people know that, wait a second, I can pull in a financial specialist. I can pull in a coach for a minimal amount of money and a minimal amount of time. But when needed, I have them on my speed dial if I need, and I know I'm not alone, and I know that I can get the right answers and or through them find the right professionals who can give me, because we all know it's better to do it right the first time than to swim upstream. And my heart breaks for people who find me post-divorce and they cut corners the first time, and now it's costing them a small fortune, when had they done it right, it would have actually cost only a fraction of what it would have done, and they would have had a much happier post-divorce life had they done it right the first time.
And a much better result.
Yes, absolutely.
So we have a few minutes left. If anybody has questions, please feel free to put them in the chat. We have the chat that's open and I will take a look at them. But while people do that, and before we sign off, last final takeaway. Lisa, what's the most important legal issue parents should address early?
I mean, it's that financials, I think we're kind of all in agreement with, but I would go second with parenting time. Making sure your custody and parenting time arrangements are, you're resolving ambiguities, you're having structured plans, and you're keeping that in mind from an early stage as well.
So, Beth, what financial planning step do they prioritize now? What's the most important thing?
Well, one thing I didn't mention is if they become aware that that there might potentially be a gift down the road, it would probably be advisable to establish a third-party special needs trust, right away, and then be able to tell family members, this is the trust that you need to name for this purpose, for my child or children.
Okay.
So I think that's, something that has to be kept in mind. The key, always to ring fence those precious state and federal benefits. And apart from that, to create a legacy for your child, to, enhance their quality of life. And that is why creating a team of professionals is so very important.
And Susan, what's the thing? What should parents remember emotionally? Like,
I
what's their
think-
tag
yeah.
phrase? Although I love the if this, then that, but that's not it.
I think three things, and I'll say them quickly because I know we're almost at the top of the hour. So one, this is temporary, right? A divorce is temporary. It's not going to last, their entire life. Number two, your child, whether they have special needs or not, did not ask for this, right? So they are now dealing with something that they did not ask for. And number three, instead of directing anger to your ex, the best revenge is living your best life and letting your children see that you're making the most of it and you're able to pivot.
Great. So we have put our contact information in the chat. Beth, if you just want to tell people what your contact information is, the best way that you can reach them. We have someone in the chat who wants it. I will provide it via email, but if you just want to give everybody that.
Sure. My number is 973-301-6320. Email is Elizabeth, ELIZABETH.McKenna, MCKENNA @ml.com.
So I just want to take a moment and thank everybody for joining us today. I really appreciate that you took the time out of your day in order to listen to these things. I am hopeful that you got a whole bunch of information, and we at least, if nothing else, were able to give you the ability to sort of allay your fears, get some information, make some decisions, and move forward. And you now have some resources that you can use to do that. So thank you, everyone.